Welcome to PATRIOTS IAS Academy. If you are new to our channel, please subscribe. There are subject-wise videos are available in our playlist. Try to watch all those videos. It will help you in your preparations. Judicial activism. It denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in the society. Judicial activism implies the assertive role played by the judiciary to force the other two organs of the government, that is, legislature and executive, to discharge their constitutional duties. Judicial activism is also known as judicial dynamism. Judicial activism is antithesis of judicial restraint, which means the self-control exercised by the judiciary. Judicial activism is closely related to the concept of public interest litigation. Judicial review and judicial activism. The former is that form of later in which judges participate in lawmaking policies. Not only they uphold or invalidate laws in terms of constitutional provisions, but also exercise their policy preference in doing so. The concept of judicial activism is inherent in judicial review, which empowers the court to uphold the Constitution and declare the laws and actions inconsistent with the Constitution as void. Judicial activism is necessary for ensuring proper discharge of duties by other two organs, that is, legislature and executive. Judicial activism stresses the importance of judicial review and a powerful judiciary in the protection and the promotion of certain core rights. The expanded concept of local standing in connection with public interest litigation by judicial interpretation from time to time has expanded the jurisdictional limits of the court exercising judicial review. This expanded role has been given the title judicial activism by those who are critical of this expanded role of the judiciary. Judiciary activism as regards the constitutional cases falls under the rubric of what is commonly called judicial review. And at the time of broadest level, it is on any occasion where a court intervenes and strikes down a piece of duly enacted legislation. So it's about the judicial review and judicial activism. Right. The Supreme Court judgments in Golaknath case 1967, Keshavananda Bharati case in 1973, Menaka Gandhi case in 1973, etc. are some of the examples of the judicial activism. Aviators of judicial activism, civil rights, citizens for environmental action, rights of child, women's poverty, consumer rights and bonded labor groups. Apprehensions of judicial activism, fear of ideological, democratic, biographic legitimation, management. These are the apprehensions of judicial activism and the aviators of judicial activism and the apprehensions of judicial activism. Then the pros associated with judicial activism in India. Judicial activism sets out a system of balance and controls to other branches of government. We have discussed it. It accentuates recurring innovation by way of solution. In case where the law fails to establish a balance, judicial activism allows judges to use their personal judgment. It places trust in judge and provides insight into issues. The oath bringing justice to the country by judges does not change with judicial activism. It's only judges to do what they see fit within rationalized limits, thus showing the instilled trust placed by in the judiciary system and its judgment. Judicial activism helps in judiciary to keep a check on the misuse of power by the state government when it interferes and harms the residents. In the issue of majority, it helps address the problem hastily where the legislature gets stuck in taking decisions. Cons associated with the judiciary activism. Firstly, when it surpasses its powers to stop and misuse or abuse of power by government. In a way, it limits the functioning of the government. It clearly violates the limit of power said to be exercised by the Constitution when it overrides any existing law. Judicial opinions of the judges once taken for any case become the standard for ruling other cases. These 3 points we have discussed in judicial review also. Judicial activism can harm the public at large as the judgment may be influenced by personal or selfish motives. Repeated interventions of courts can diminish the faith of the people in integrity, quality and efficiency of the government. Why judicial activism needed? When the legislature fails to make the necessary legislation to suit changing times and governmental agencies fail miserably to perform their administrative functions, sincerely it leads to an erosion of the confidence of the citizens in the constitutional values and democracy. In such a scenario, judiciary step into the areas usually earmarked for the legislature and executive, and the result is judicial legislation and a government by judiciary. In the case of the fundamental rights of the people are trampled by the government or any other third party, the judges may take upon themselves the task of aiding and ameliorating conditions of the citizens. You can write the conclusion: judicial activism is a product fabricated solely by the judiciaries and not backed by the Constitution. When the judiciary surpasses the line of powers set for it in the name of judicial activism, it could be rightly said that the judiciary then brings to invalidate the concept of separation of powers set out in Constitution. If you like the video, please subscribe our channel. Please share the video with your friends. There are other subject-wise videos are available in our playlist. Try to watch all those videos. It will help you in your preparations. Thanks for watching.